Hi, this is Chandrashekhar Prabhu once again. We have been doing case studies, and a whole lot of societies have been sending us their case studies saying that please talk about our society. As you know, 5,800 cooperative housing societies and projects are stuck. So there will be innumerable societies which will be coming to us asking for us to do case studies. A lot of them, almost all of them, have been cheated by the builders. But they are scared. They feel some of them have got 2 years rent and the remaining years no rent has been paid. Some of them have been paid rent for 4 years and they are scared. Why they are scared is very simple. They feel that the money that the builder has spent from them, if that is to be recovered from them, they do not have the wherewithal to pay with this money back. And so they keep on asking me, yes, we will remove the builder has cheated us. But what will happen? What if we have to pay the money? We do not have the money. Genuinely, the money that was paid as rent or as brokerage or as shifting charges has been spent. So how do we reconcile with this? This is the question that everyone asks. Today we are going to reply to this question. We will reply to this in the form of a case study of a cooperative housing society in Nehru Nagar. About 14 years ago, this cooperative housing society was approached by a developer. The developer has done other cooperative housing societies redevelopment in Nehru Nagar itself. Citing his possibility of his working with other societies, he asked this particular society to sign up an agreement with him. In good faith, the members of the society decided to sign up with him. He then asked them to vacate the buildings because he said, unless you vacate the building and the building is demolished, I cannot move further. They vacated the building without even checking what he's going to do. They just got 1 year's rent and they took the rent and they vacated the building, found for themselves different other places. After 3 years, up to 3 years, he kept on saying, I'm doing it, very soon I will start. Under the agreement, he was to complete the building in 3 years. After 3 years, when they went to the builder, he said, yes, of course I am doing. One of the members went to MHADA to check what the progress is. Another member went to the BMC to check because in those days the plans were to be approved by the municipal corporation. Now, lands on MHADA building like Nehru Nagar, buildings on MHADA lands like Nehru Nagar have specifically separate system of approvals where MHADA does the approval. However, in those days, the municipal corporation did the approvals. They were shocked to know that after 3 years, the plans were not made, neither submitted to MHADA nor submitted to the municipal corporation. They requested the builder time and again. He said, don't worry. If you've given it to me, as long as you get the rent, you don't have to worry. I'm there to pay the rent to you. And it went on for another year or two, the rents were paid. After that, the builder stopped meeting the members of the society and stopped taking their telephone calls, and the rents were stopped. The tenants waited. 1 year passed, 2 years passed, 3 years passed. Finally, the tenants decided that they must take some action. In a general body meeting of the tenants, it was put to vote and unanimously decided that the builder should be removed. And whatever agreement they had done with the builder was terminated, and it was informed, it was communicated to the builder through the lawyers and through the general body. The builder was extremely infuriated that he has been left in the lurch. He said, I gave you rent for so many years and you are now going back on your word. The resident said, we are not going back on your words. You get the plans approved and you start the building. We are okay with that. He started giving flimsy excuses. Finally, he went to court. And the matter came up before the Bombay High Court, and he asked for arbitration because in the original agreement there was an arbitration clause. For arbitration, a retired Chief Justice of the Bombay High Court was appointed as a single arbitrator by both the parties together. Both the parties decided that collectively contribute towards the expenses of arbitration. In the arbitration, the builder argued that he had made major amount of expenses. He could not produce receipts for that. But he said for 5 years, all the members of the society, I think they were 70 or so, have been given rents. And I need all the money that I have paid with the interest back. The arbitrator listened to all the claims by both the parties. He listened to the claims from the builder and listened to the claims from the cooperative housing society. The society said very simply that since in the agreement the builder has said that he will pay rent till the new building is completed and we are shifted into the new building, he should continue to pay the rent. The builder said, I have paid rent for so many days, they have terminated me, so they should give back my money. It was an issue of specific performance. The former Chief Justice of the High Court, after hearing all the party, gave a thumping judgment. He said that the rents, the brokerage and all the expenses incurred by the builders was as a part of his business expense. If he would have completed all the things that he promised under the agreement, this expense would have paid him back. But he was the one who did not do anything. He did not prepare the plan. He did not submit it to MHADA. He did not take a NOC from MHADA. He did not submit it to the municipal corporation. So if the delay is on his part, by the time this arbitration happened, more than 10 years had passed. So the arbitrator said, nothing doing. The builder is not entitled to even 1 rupee. All the expenses that he has done was done to procure business, and any expenditure done to procure business cannot be recovered back from the party which is affected, which is the victim of your cheating. Not just that, they said that till the date of the arbitration, all the rents that were balanced, 3 years rent or something, must be paid. And the arbitration did not stop at that. They said it's not just the rent, but over and above the rent, there should be the money which the society has claimed. That money has to be paid to the society. So the builder had to pay about 50 lakhs of rupees back to the society and pay rents also. The builder naturally, once the arbitration award had come, challenged the arbitration award before the High Court. The matter was discussed and argued at length, and the High Court came to a conclusion that the arbitration is correct and that the builder has to pay not just what the arbitrator has ruled, but the High Court imposed a penalty on the builder, saying that pay this much what the arbitrator has said, but pay more money. The builder did not stop at that. He got about 50 people, outsiders, rank outsiders, to file a case for intervention in the High Court and went to appeal against the judgment of the single bench of the High Court to a division bench. And they said that we are outsiders. We were told that this builder is going to build a building, and we booked flats with him. We have paid him. Somebody said 50 lakhs, somebody said 1 crore, somebody said 1.5 crore, somebody said 25 lakhs, and 50 people approached the High Court division bench. The division bench heard them out. And the final verdict of the division bench was that the arbitration award given by the former Chief Justice was correct. The judgment by the single judge bench was also correct. The division bench ruled that the bookings that were made by rank outsiders were bookings which were made with the developer and has nothing whatsoever to do with the original residents and the cooperative housing society. So it was made very clear to them that the division bench judgment said not only pay the penalty which the single bench has put on you and the arbitrator has put on you, but you shall also pay the legal charges that the cooperative society has to bear to sustain such a long litigation. They were really lower middle class people, and the High Court took cognizance of the fact that they cannot afford the expensive litigation processes and the payment to the lawyers. The builder did not stop at that. With the division bench of the High Court ruling against them, the builder went to the Supreme Court. He naturally thought that how will these poor residents of MHADA colony living in one room kitchen, how will they go to the Supreme Court and challenge it? How can they afford the exorbitant prices that are charged by the Supreme Court lawyers? And really the people did not have the money. However, their lawyer, who was a resident of the building, decided that he will go to Delhi. The residents contributed whatever little they can. And in Delhi they found a good lawyer who said that I am convinced that you are being cheated and I will not charge you my fees. Whatever you can afford, you may pay. And the matter was argued before the Supreme Court, and Supreme Court confirmed the ruling, confirmed that the arbitration was correct, the arbitration award was correct, the single judge bench ruling was correct, the division judge bench of the High Court ruling was also correct, and the Supreme Court imposed a further penalty on the developer and said that all the legal fees that the society has to bear, because they had to come to the Supreme Court, they were dragged to the Supreme Court, has to be paid by the developer. So this case study of Nehru Nagar is loud and clear. It tells to all the cooperative housing society who are worried that we have taken some advance from the builder, we have taken some rent from the builder, we have taken shifting charges from the builder. Builder has paid some money towards conveyance of our building. Builder has done some little bit of construction here and there, and he's likely to demand all this money with interest from us, and we will not be in a position to pay him. These are the fears. However, this case study very clearly says that such expense such as rents and other things which if the builder has spent will never be recovered from the tenants at all. And if the builder says that I have given booking to X number of people, the High Court and the Supreme Court told those people who have done the booking that please go to the builder and recover your money. File a case against him, attach his other assets and collaterals and get your money back. But the poor residents of MHADA colony living in one-room kitchen will not pay your money. This is the kind of case study that I wanted to present before you, so that anybody who is cheated by builder is worried that the builder may ask the money back. There is a case law, there is arbitration history, there are innumerable single judge bench judgments, there are innumerable division bench judgments which have been confirmed by the Supreme Court. So now it has become a case law that if the builder cheats you, he cannot really ask for the money that he has paid on the grounds of rent and other things. So those who have been cheated by the builder, be rest assured that if the builder threatens you to take you to court and you are worried that you do not have the money, you cannot afford to have lawyers, please understand that you may have to contribute a little in advance to appoint a good lawyer. There are very good conscientious lawyers who do not charge too much and who do it at cost. There are also lawyers who work on a pro bono basis. Because the case law is very clear, you will be protected and you will not be thrown to the wolves. With this case study, this is Chandrashekhar Prabhu bidding you au revoir, promising you to be back with new case studies and new videos. Please watch and comment. Bye for now.